Thank you very much. Good morning. I'd like to thank you so much for having me here today. It's wonderful to be visiting Mexico for the first time, and I've enjoyed such warm hospitality here. I've learned so much over the past few days from my Latin American colleagues during this conference, and I'd also just like to thank the translators who've done such a wonderful job and enabled me to participate more fully in this conference with my terrible Spanish. Now I'd like to share a little bit with you about Canada. I'm a law librarian at Queen's University, which is a university of about 25,000 students in a small city called Kingston. Like the vast majority of Canadian universities, Queen's is publicly funded, though the proportion of university funding that comes from the government has been diminishing across the sector in recent years. Nonetheless, there's a sense in Canada that university education is a public endeavor. I've long been interested in public access rights to universities and the rich resources they house and create. A few years ago, I researched the case law in Canada and the United States to see if courts had recognized a public access right to academic libraries. Some of the strongest arguments for that public access were based on the public status of a university and the amount of public funding it might receive. I found that courts did not find a public access right on either of those bases. Rather, it was the policies of libraries and the patterns that those libraries and librarians allowed for the public that were more persuasive to courts. I've learned a few things from that study that have helped me think about the question today, about identifying the foundations that affect access to specialized information and data, and what we as librarians are doing and might do to expand what is in the public domain, easily usable by people so that they can participate fully in society, regardless of their income or affiliation. Thank you. For my talk today, I'll begin by identifying the legal structures surrounding publication and dissemination, identify rights and practices that have worked to push against restricted access, and talk about policies that have changed the scholarly publishing landscape in Canada. Then I'll move on to center us as librarians as actors and show you what some Canadian librarians have done collectively and individually, particularly in regard to government information, and conclude from there. In Canada, the most important statute for this conversation about open and restricted access to information and data is the Copyright Act. I'd like to highlight a few parts of it that are particularly relevant to our discussion today. The Copyright Act is intended to be a balance between creators and users' rights. And in the case of Théberge, our Supreme Court explained that it is a balance between promoting the public interest in the encouragement and dissemination of works of the arts and intellect and obtaining a just reward for the creator. Copyright is something specific. As one of our courts of appeals stated, it protects an original mode of expression, not the idea expressed. So it is really because it comes from the print era. It is the arrangement on the page. If a work is subject to copyright, the ways it can be reproduced are restricted and subject to legal requirements. Copyright is the main mechanism for restricting access to specialized information and, debatably, data, depending on its form. The Copyright Act enumerates what is protected under it, and for our purposes, I wanted to highlight some of those works. So they would include things like paintings, drawings, maps, charts, plans, photographs, engravings, sculptures, works of artistic craftsmanship, architectural works, and compilation of artistic works. It also protects literary works, and under literary works, those include tables, computer programs, and compilations of works as protected. Data is a little more complicated. As our federal court has indicated in this quote, the appropriate test to be applied when copyright is claimed for works that consist of compilations of data has been a difficult area. This is because such works are not likely to exhibit on their face indicia of the author's personal style or manner of expression. Because it is the mode of expression, not the idea, that is protected by copyright, when we bring this idea to data, we see that data itself can't be copyrighted, but the arrangement of data can. For example, data formatted into a data set or into a graph or chart could be. It's really the arrangement that is key. So here, another Canadian university, Simon Fraser University, when it was explaining this difficult legal concept that we still can't really get to the bottom of, it posted this slide, which is of average rainfall in Vancouver by month, and they said, this is really debatable. We don't know if this would actually attract copyright or not, just to give you an example. I'm going to skip the next few slides because what they cover has been covered so well already. When the copyright to most of the specialized information produced by academics is owned by big publishers, in Canada, that means often mostly multinationals, this is what has happened. We have costly access for academic libraries that can afford it, and restricted access for the rest of society, especially we're talking about the people who paid for the research in the first place. However, there are two tools in Canada, one legal and one policy-based, that I'd like to talk about that can push against this tendency. The legal tool is what we call in Canada the right of fair dealing, and the policy tool is through research funding agencies. And I'd like to talk about each in turn. Fair dealing is a right in the Copyright Act, in some ways similar to fair use in the United States. So even when copyright exists in a work, there is also the user's right of fair dealing. The Copyright Act sets out which purposes can be considered fair and therefore not infringe copyright. There are purposes outlined in the Act, such as what I've put on the screen. Purposes such as research, private study, education, parody, or satire. There are also a few other purposes, such as criticism or review and news reporting. It's important to note that fair dealing is not an exemption to what would otherwise be an infringement of copyright. It is a user's right. And this is an important distinction, that it's not an exception. It's a right alongside copyright, and those two rights will come into conflict, and the conflict will need to be resolved. We know a bit about what fair dealing means because, as you can imagine, this right has been litigated. When someone brings a case forward alleging that their copyright has been infringed, and the respondent asserts, no, it's not an infringement, it was fair dealing, they must show that both the purpose and the use of the work are fair. And these are the factors the court will consider, and they come from a case from the Supreme Court. They'll consider the purpose, character, amount, alternatives to the fair dealing, nature of the work, and the effect of the dealing on the work. There are also particular exemptions from that copyright for education institutions. They can make copies of works on their premises as long as there is no motive for financial gain, but they must pay royalties and keep records. Libraries can also make copies for preservation or for other people under certain circumstances. In recent years, educational institutes have interpreted their rights under fair dealing very differently from publishers. Until about 2011, the standard practice for universities was to pay a per-student fee to a collective agency, Access Copyright, for the right to copy materials or post them for their students' use. Starting around 2011, with a changing legal landscape, a number of universities, including mine, and York University, which is a large university in Toronto, formally opted out of the system, and they took the position that they would comply with copyright laws through other means and not pay any royalties, the license. Many Canadian universities now operate under variations of a model of fair dealing policy. In practice, this means a combination of using materials already licensed by their library, paying for copyright clearance for individual items as needed, and most centrally, relying on their fair dealing rights. Access Copyright, the collective licensing agency, took York University to court, saying York was not allowed to opt out of the per-student licensing fee and that its fair dealing guidelines were actually not fair. The trial judge recently found in favor of Access Copyright and against the university. That decision is now under appeal, so the legal landscape with regards to fair dealing by education institutes in Canada is very unsettled. As a law librarian, it's sometimes tempting to think that most things can be solved by law, but we know that isn't true, and there are many other ways to approach problems. And one way that the Canadians are looking at expanding access to restricted information and data is through the policies of the big funding agencies for research. So there's the Canadian Institute of Health Research, the Natural Sciences and Engineering Research Council, and the Social Sciences and Humanities Research Council. These are the three big publicly funded research funding agencies. Since 2015, the three agencies have adopted a harmonized open access policy for scholarly publications that they have funded. CIHR's open access policy has been in place since 2008. And the main elements of their policy are that you have to ensure that peer-reviewed journal publications arising from their funding are freely available within 12 months of publication by depositing the manuscript in an institutional or disciplinary repository and or publishing in an open access journal. However, it's worth observing that compliance levels for this policy range from 23 to 40%, depending on which agency we're talking about, and that the agencies do not enforce them, preferring to use an encouragement approach, and that's a quote. A 2018 study by Vincent Larivière and Cassidy Sugimoto, published in Nature, identified a few factors that may account for the low rates of compliance with Canadian open access policies, including the fact that there's a 12-month window for deposit rather than deposit upon publication, the fact that there's no specific dedicated infrastructure for deposit, that the grants are generally lower compared to, for instance, the United States, which would leave less money for things like article processing fees, and the lack of compliance tracking by the agencies. Currently, there is no tri-agency policy on data deposit. However, the Social Sciences and Humanities Research Council has had a long-standing data archiving policy, and I've put its current policy on the screen. All data must be available for public use within 2 years of the completion of the research project. The Canadian Institutes of Health Research data deposit policy is a little more nuanced. It's dependent on the type of information. It depends on the type, depending on the type of information, there will be different places where it should be deposited, or perhaps why it should not be deposited if it's, for instance, patient information that is subject to confidentiality. Finally, the NSERC lacks a policy on data deposit at this time, but all three agencies are working on a harmonized data deposit policy. After outlining the legal and policy framework, I'd like to turn to what librarians are doing and have the potential to do to make more specialized information and data more available to the public. But we can't do it on our own. As a central part of the scholarly publishing ecosystem, we can do a lot. As we've seen over the past 3 days, we're well positioned to do this work. After all, we have the expertise, we have the technological infrastructure, and we already have lots of experience working together to scale up efforts. And we can also build on existing consortia for this work. I'd just like to briefly talk about the local scholarly publication and research repositories, using my own university as an example. So in recent years, we've developed our own local repository, T-Space. We also have a library journal hosting service, so people can start their own journals and we will assist them with their editorial boards. on the Open Journal system and make sure it's discoverable through various indexes. And then we also have some open educational resources. This is a service we're just starting to build to assist faculty to create and customize open textbooks. I was really impressed to hear from Sean yesterday about what the University of Arizona is doing. Ours is a smaller effort. The library will work with the faculty member at each stage of the open textbook project, from planning to publishing and distribution on the Pressbooks authoring platform. Over the last 2 years, we were able to secure funding from the provost to encourage faculty to think about doing this. And we usually get about 3 a year that we can help fund. And with 3 open textbooks in 1 year, according to the author's estimates, it's saved students at my university approximately 817,000 pesos per year. And these are 3 of what are now 328 open textbooks on my province's open library, which is eCampus Ontario, that anyone can use. And they've estimated the total savings from the eCampus Ontario open textbooks to be over 77 million pesos. So it's saving students money. So data. This is the way we talk at my university about helping faculty fulfill their data deposit requirements. We see ourselves as their data curation partner, and we also expect that as data deposit requirements increase, so too will our services. So we talk to faculty in terms of managing, documenting, preparing, preserving and archiving, and sharing their data. Sorry. Getting beyond the local. Sorry, I must be going the wrong way. Yes, sorry. Getting beyond the local, libraries like mine are helping to provide robust data repositories. We have a provincial instance of Scholars, or of Dataverse, which we call Scholars Portal Dataverse. We've been part of establishing the Portage National Network of Research Data Management Expertise, and also developing a data management planning tool for researchers. It's called the Portage DMP, or Data Management Project Assistant, which is a tool even a non-specialist like me can use to talk to my faculty about planning a data project. And then there's also FERDR, which is Canada's Federated Data Research Repository. There are many types of specialized information, and each has its own challenges in terms of access. As a law librarian, government information is a type I deal with often. While it may often appear to Canadians that government information is freely available because of how many pages of government websites there are, and agencies like Statistics Canada that provide extensive public dissemination of data and statistics, there are 2 problematic aspects I would like to highlight for you and show you what librarians are doing to address them. So born digital government documents can disappear. And I've just put up the title of a recent article. And where we really find this is when there's a change in government. So last year, when a province called Alberta had a change of government, there was a real fear that a lot of the information would go away right away. So a librarian named Kate Collier at the University of Alberta took it upon herself to archive the pages as soon as it was clear that there was going to be a change of government. And then she put it on, it's on the University of Alberta website and also on the Wayback Machine. And then there was a similar effort in my province, in Ontario. This year we also got a new government, and web pages, especially to do with environmental initiatives, were just suddenly going down. And so a librarian named Nick Warby at the University of Toronto did a similar thing in archiving the information and then putting it both on the University of Toronto website, but also into the Internet Archive. Is only a fraction of government information. Much of it is never published in the first place, and some of this information is very important and relevant. Canada's access to information and privacy laws govern that government information and what private citizens can request and how they can request it. So the overriding purpose of the law is to make public bodies more accountable by allowing people to access records, with exceptions. It can be difficult to define the scope of the request without any context, because when you put in your request, you have to define the scope. But if this is unpublished information, how do you define the scope of what you're looking for when you haven't seen what it is? There may be fees attached, and it can take a long time to receive the documents. Newspaper reporters who rely on being able to access government information this way give us a glimpse into how difficult this process can be. So when a Toronto Star reporter wanted records related to a proposed subway extension, it cost her almost 22,000 pesos and took 2 years to get. And she said, "It concerns me that a system purporting to be designed to allow access to public information was set up to be incredibly onerous on the person seeking the information. The result is often legislated secrecy." Since this information can be so difficult and costly to obtain, one way that librarians can help the situation is to provide a place for the information to be publicly archived. So this repository that I've just put a screenshot of on the screen is a result of a pilot project between my library and the Surveillance Studies Center at my university to establish an open access repository for open government information released under access to information requests. Right now, it currently contains a sample of a release request from the Canadian Security Intelligence Services, or CSIS. But it shows what we as librarians, we can think beyond just scholarly publications and data and use that existing rich infrastructure to make sure other types of specialized information is openly available. So I've described some of the laws, policies, and technological frameworks that are driving what information is open and what stays closed in Canada. But as with most things, it's the people who make the difference. And with the opening up of data and specialized information, librarians are the people with the expertise and broad knowledge to navigate this complicated ecosystem. Whether we are talking about vast consortial initiatives or individual actions, they all start with us thinking about what is locked up and shouldn't be, and deciding what we need to do about it. Whether it's working to challenge a law, getting buy-in for new policies, or developing new tools to make it easy for people to open up their work, it all contributes to an environment where access to information becomes less of a privilege based on who you know, your level of education, or how much money you have, and more of a right. Thank you for your attention.